Thank you for joining us. If you're just tuning in, we just heard a lot right there. Kent County Prosecutor Chris Becker and Christopher Schurr's team arguing over what facts should be allowed in the case, including a domestic violence warrant out against Patrick Lyoya. Now, Callie Lichter is live right now with more on what happened. Callie, break down what was happening during that argument.
So we actually have an expert here to help break that down. You know, I'm in court a lot, but not quite an expert. So if you'd like to introduce yourself real quick.
Sure. Tonya Krause Phelan. I'm a professor and associate dean of academics, and way back in the day, I actually used to try these kinds of cases.
Yeah, you're telling me you have a lot of experience here in the courtroom, trials.
Yes, but please don't ask me how old I am. Yes.
I won't, I promise. So let's go through, this motion hearing that, we just heard. They had the jury leave the courtroom for it. What kind of were they arguing in there?
So first of all, kudos to the lawyers for actually asking for the jury to be excused before they made this argument, because I've seen in a lot of situations where lawyers start arguing something that they want to keep out of evidence, and then they do it in front of the jury, and then the jury hears it anyway. So kudos to the lawyers for that. Essentially what Prosecutor Becker was asking for is a clarification from the judge on what specifically was going to be allowed with respect to Mr. Lyoya's prior criminal history. There had been a ruling before trial, right, that they couldn't get into certain things, but because some things came up in trial today, Mr. Becker renewed his motion on that particular matter.
And I know he was saying it was kind of a preemptive thing, but we were also talking about how maybe Lyoya's previous history was kind of danced around during what we've heard today.
Sure. So one of the things that's really important to remember is that the Michigan rules of evidence in homicide cases where the defense is self-defense, and we know in this case that's clearly the defense, it is permissible or allowed for the victim's reputation of aggressiveness to come into trial. And what Mr. Becker was arguing is like, look, there's no evidence that Officer Schurr knew about that at the time this incident happened, and that's why he wanted to keep it out. But oftentimes what happens in trial is, even when you're well prepared, even when you've interviewed witnesses countless times, something always comes up in the course of trial that you didn't expect, because jurors are human beings and they're in there, they're nervous, they're talking. And so I think he wanted to make sure that everybody stayed within the bounds of the judge's ruling, that impermissible evidence did not come in.
And, I know that this motion was already heard. It was, I think 2 weeks ago now, there was a ruling on it, some time ago, but it's not uncommon for, these issues to kind of continue into a trial setting.
Sure, that's absolutely right, because just as I mentioned, even though there was a ruling ahead of time and the lawyers can try to ask their questions so that that type of evidence doesn't come out, the witnesses don't always know that, right? And the witnesses are there to talk and tell their version of what they saw, heard, experienced as it relates to a case. And so if they say something unexpected, it could trigger something to happen within the rules of evidence that might allow evidence to come in that the judge had previously ruled out. And I think that's what Mr. Becker was trying to prevent from happening.
And I know, there's an alleged storied history there with Lyoya. In regards to his previous record, there was some convictions, domestic violence. I think there was also a driving under the influence type of record. And I heard the defense try to, bring some of these things up. And you had Prosecutor Becker say, well, these aren't violent offenses. Would it be common to allow, in theory, allow some of these prior convictions warrants to be able to be shared and others not to be shared?
Right, because again, the issue here, when self-defense is the defense, is what was going through the defendant's mind at the time. Was he in fear of imminent death or great bodily harm? And to get inside the person's head, you need to assess the situation as it appeared to them. So that's why you heard Mr. Becker say, look, there's no evidence that Officer Schurr knew about those things ahead of time while this was happening. So that's how somebody's prior reputation or actions for violent conduct could come in a homicide case where self-defense is an issue. Now, if this were a trial and Mr. Lyoya had survived and was testifying against Officer Schurr, then there are certain rules of evidence that pertain to prior convictions, which is different from actions regarding a reputation for aggressiveness.
And I know we were talking in general, there's two pictures painted by both sides, and the defense is going towards that, self-defense. He was in a state of, they say that Schurr was in a state of fear, when he was in this situation. And we were talking about, the amount of times he called for backup and he was alone. So what do you think about, their approach to this?
Yeah, and so it's really difficult for defense attorneys oftentimes to know what exactly to say in an opening statement, because the defendant in every criminal case in this country has the right to either remain silent or take the stand and testify in their own behalf. But in a case like this, where we clearly know that self-defense is the defense, they wanted to paint the picture of what could possibly have been going through his Officer Schurr's mind at the time this happened. And that's a delicate line, right? Because the defendant hasn't testified yet. And so you heard a couple of times the prosecutor object to the defense opening, saying it crossed over into argument when she started talking about things that Mr. Schurr or Officer Schurr might have been thinking at the time. We don't have any evidence of that yet. But it was clear from trying to set the stage of what could possibly have been going through Officer Schurr's mind at the time, right? How many times he called for backup? Twice, and nobody was there yet. And so that will, I predict, become relevant when we get to the defense case, because that's going to be part of his state of mind and what he reasonably feared as imminent harm. Prosecution, on the other hand, set a different stage for the story, and that was that a single shot to the head killed Patrick Leola. And that ties in with the element that he has to prove, that there was an intent to kill when Officer Schurr pulled the trigger. So both attorneys did a really nice job in their opening statements, setting the stage for what their theory of the case is and the story from their perspective about what this case is all about.
And I know we were also talking about, how important stories are when it comes to trials, to telling and painting a broader picture. And we saw a few witnesses that did just that. The three witnesses, his two friends, the neighbors that were there. But then we're also seeing some witnesses who are more procedural in a way, seeing the videos, seeing the photos. So can you talk about, kind of how they're blending two elements, the more like facts, or they're all facts, but the more statistics, evidence, and then the stories.
So far what I'm seeing is that Mr. Becker is going pretty much in chronological order, which is a very common procedural way that prosecutors put their case on. But in this case, when we have so much video, we have cell phone videos, we have door cams, we have the officer's body cam and dash cam video, and then putting those images alongside of the eyewitness testimony, the officers arriving on the scene, I think really helps give the jury a full view of what, kind of a 360, if you will, of the prosecutor's theory of the case.
And I know we were told this morning that there was going to be some officers coming in on the when the defense has their turn to bring in their witnesses. And I know we're talking a lot about, and the defense was talking a lot about how he was doing his job. Schurr was doing his job as an officer. We don't know who's going to take the witness in for the prosecution. But do you anticipate maybe some officers coming in and saying that towards the, for the prosecution's witness list, saying, no, this wasn't procedure?
Well, Mr. Becker alluded to the fact that they do have police officers coming in to testify as expert witnesses on the use of force, so I fully expect that he will make good on the promise he made in his opening statement, that we'll see that. And the defense also referred to the fact that they'll have a similar expert witness on the other side. And so both experts, whether it's the prosecution expert or the defense expert, are going to focus in on the training officers receive regarding escalation of force in these types of situations, and whether Officer Schurr's conduct exceeded what they're trained to do.
And one of the things that I found personally interesting is, a lot of the argument on both sides surrounds the taser. The taser, it's in the courtroom right now. We saw it on the table. It was picked up a couple of times, and there was a ruling that there can't be a live taser demonstration in the courtroom. So how is that going to play in your opinion, that the fact they can't have a live taser demonstration, but they're, having it in the room just as kind of a static object?
Yeah, that's not uncommon, right? So the evidence is what the evidence is, and it's very common for the prosecutors to have that evidence out during the course of the trial. I'm not surprised at the ruling that there wouldn't be a live taser demonstration. It would be interesting to see if, as the case evolves, that they allow a video to be played about what happens when if it's tased on someone. So we'll see how that plays out. But so far they're abiding by the judge's ruling.
And, we can't predict what's going to happen when it comes to trials. It's ever evolving, ever moving, and we can't predict how many people are going to come in, how many questions are going to be asked. But so far we've seen, I think, maybe 6 witnesses, if I'm remembering correctly off the top of my head. Is it moving fast, slow when it comes to other trials like this? How do you think the pace is shaping up?
Well, 2 things there. First of all, every trial is different, and I've had trials where I thought it was going to go very quickly, and it ended up taking twice as long, and vice versa. I will say that I think we're going along at a pretty good clip right now. I think the pace is pretty good, and that's an attribute to the lawyers being very good lawyers, right? Mr. Becker is keeping his questions very focused and direct when he's bringing his witnesses up there, and so far the cross-examinations have been very targeted, pinpoint questions. They're not droning on and trying to get to a point. They have points they want to make, and they make it. So when you have good, talented trial lawyers like you do on both sides of this case, it's not uncommon for the case to go a little quicker than expected.
I think it's getting just about time for the viewers to get back to the stream.
Okay.
So thank you so much for
You're
coming in and
welcome.
sharing your expertise. And Lauren, I'm going to send it back to you in the studio.
Callie, thank you. One of the